Mr. Attorney, you have spoken about your work as the Chief Legal Advisor and Counsel to the government. Your greatest help in this respect will come from the core of legal service officers who work in your chambers and in the ministries and the statutory boards. I'm familiar with their quality and dedication. I commend your commitment to continue the emphasis on their training and development. Officers in the legal service play a critical role in fearlessly upholding the rule of law. During his welcome reference in 1990, Chief Justice Yong spoke of his desire to groom the best officers for appointment to the Supreme Court bench. This is a sound aspiration for those who have chosen to invest a lifetime in the public service, and I welcome anything you do to better prepare the best officers for this. Turning to the Supreme Court, I'm happy to say that through the efforts of previous Chief Justices and the registrars, it is in very good shape. I must give particular credit to the registrar and his team of outstanding judicial as well as non-legally trained supporting officers for their commitment and diligence. It is they who ensure the smooth running of the court. They have been immensely helpful to me in every way, and I'm very grateful to each of them. Thanks to their efforts and the work of the judges, I'm happy to report that we remain in the happy situation of not having a backlog of cases to contend with. We continue to meet our rigorous key performance indicator of clearing 85% of all writ actions within 18 months. Appeals are disposed of timelessly, and judgments have become more learned over time, if also somewhat longer. There are nonetheless some priorities that we will work on initially. First, on the electronic front. E-litigation was previewed last October, and the first electronic filing phase for cases at the Supreme Court was launched just 2 days ago. We have set the standard internationally in this area for some years, and I'm confident that e-litigation will come to be seen as yet another pivotal point in the use of technology by the Supreme Court. The e-litigation system brings the use of electronic tools in litigation to a higher level by introducing a suite of changes targeted at reducing inefficiencies, by allowing lawyers to obtain online access to case files. It will reduce their dependence on physical files and allow them to conduct searches electronically regardless of where they might be. An extensive review of the procedural rules and processes has also been undertaken to do away with many unnecessary procedural steps and to more effectively utilize information that has already been filed in court. These shortcuts integrated within e-litigation will ease some of the burden for all users by enabling court documents to be generated electronically from information that already resides in the system. Next, there are the issues arising from the discovery process when working with electronic documents. The practice directions on electronic discovery provide a set of procedures for the discovery of such documents. They encourage the exchange of electronic documents in their native electronic format and establish standards for adapting discovery principles to new media. The courts have also delivered a number of decisions which interpret these practice directions. To facilitate the acceptance and implementation of these changes, a call for collaboration was issued last year by the Singapore Academy of Law with the support of the Infocom Development Authority of Singapore, the Supreme Court, the subordinate courts, the Attorney General's Chambers, and the Law Society. The successful bidder will make available to all lawyers at a subsidized rate a cloud-based document review platform for conducting electronic discovery through LawNet. They will also establish a capacity building program for lawyers and paralegals. The key driver for these two initiatives is the push to enhance the productivity of lawyers. The courts have streamlined the procedural rules and processes with the launch of e-litigation. The challenge now is for the bar to embrace the use of technology and adopt efficient practices. With the right skills, lawyers will be able to make use of the full range of electronic tools to search, tag, and manage documents. This, together with the streamlined procedural rules and the case management features that are embedded within e-litigation, will help to alleviate the potentially disproportionate and prohibitive expense associated with reviewing large numbers of documents manually. The third major priority will be to review our case management processes. The most fundamental change will be the shift to a modified docket system of litigation in the High Court. Cases will be assigned at an early stage to specific judges and registrars who will manage and prepare them for trial. We stand to derive many advantages from this. Judges would have been involved in dealing with the interlocutory processes along the way and will be fully familiar with the case by the time it is fixed for trial. Judges will also ensure by active management that cases are disposed of efficiently and that adjournments and the disruption of having matters part heard are minimized, if not avoided. This will also enable a degree of judicial specialization, with each judge being assigned to specific lists. We will also change aspects of ex parte processes and review our approach to costs awards so as to incentivize appropriate behavior in litigation. In the Court of Appeal, we will also see some changes in the coming months. Among them will be measures to do away with excessive prolixity in written cases with the introduction of page limits, as well as a greater degree of case management by requiring counsel to provide specific information at an early stage so that the issues are distilled and adequate time is allocated for oral arguments. Lead counsel should not be surprised if I ask to see them some weeks before the hearings in order to better customize the time allocation for cases. This may require a change of practice and mindset, as senior lawyers will need to review the case and the associated documents at an earlier stage than might hitherto have been the practice. Where difficult and important issues of law arise, the Court of Appeal may more readily appoint amicus curiae, and where appropriate, they may be drawn from the ranks of our academics. The last major priority I want to mention pertains to the tremendous opportunity that I believe exists for the profession in Singapore to service a wider region. We have seen the great success of the efforts to promote Singapore as a hub for international arbitration. Much of this work emanates from abroad, but parties have chosen to arbitrate here. There are many factors that account for this, and it is time to take fuller advantage of them. I have discussed the matter with the Minister for Law, and we have agreed that Justice V.K. Raja, together with the Senior Minister of State for Law, should lead a group that will include other judges of the Supreme Court, as well as representatives from the Ministry of Law and other stakeholders, to study the viability of developing a framework for the establishment of the Singapore International Commercial Court. From my preliminary consultations, it appears there will be strong interest in this from the community of legal corporations operating throughout Asia. This promises to be an exciting and important step in our efforts to grow the legal services sector and to expand the scope for us to internationalize and export Singapore law. I look forward to the detailed recommendations of the working group that will soon be established. Let me turn to the Academy. This year marks its 25th anniversary, and several activities have been lined up to commemorate this. Later today, we will launch the 25th anniversary logo and a microsite detailing the Silver Jubilee program. A number of conferences have been lined up as the Academy continues to brand itself as a premier provider of world-class conferences, bringing together thought leaders from Singapore and elsewhere. Among the most outstanding of these is a joint conference of the Academy and the Chancery Bar Association of England and Wales that will be held in April this year and will bring together some of the most illustrious practitioners and thinkers from here in England to speak on finance, property, and business litigation in a changing world. In July, the Academy will provide the public with an insight into the law with a week-long series of law seminars, free legal clinics, and an exhibition on our legal history. And in October, a charity concert is planned to showcase the profession's talents while raising funds for the Yellow Ribbon Project. I look forward to the active participation of the membership in these events. Beyond this, I think it is timely for us to consider ways of ensuring that the Academy remains relevant and vital to its members as we face the future together. I have accordingly asked that a dialogue be convened with the key stakeholders to this end. Finally, the Academy will also introduce a new and improved LawNet portal by the end of this year. The most innovative features will include the facility for members to make and store their personalized annotations on the resources they use. Using personalized identification data, members will have permanent and secured access to their own library of annotations, and in keeping with the times, they will be able to access LawNet using their tablet devices. I have reached that stage of the proceedings when it falls upon me to announce the appointment of senior counsel. This year, we have appointed 2 advocates as senior counsel. As they join the highest ranks of the bar, it will be incumbent on them to meet the expectations that come with this. They are Mr. Narayanan Srinivasan and Mr. Lionel Yee. On behalf of the judiciary, I congratulate them on their appointments. This brings me to the close of this morning's proceedings. I return at this stage to the quest I have mentioned to persist in the effort to make things even better than they already are. This is a quest that must unite all of us in the legal community. If the law is foundational to society, then we who are the servants of the law must constantly reflect on how we can make it more responsive to the needs of our evolving society. We must ensure that we do not price the law out of the reach of the average Singaporean, that we are guided by our care and concern for those whose lot it is to come face to face with the law, and that we do not allow the law to become the preserve of the rarefied few as a result of systems, processes, and outputs that seem obscure or even confounding to the reasonably informed layperson. I have been blessed with a superb bench, and I am optimistic about the future. I am assured by the commitments that I have received from all those I have spoken to. The courts will remain responsive to the needs of our citizens by working to ensure the fair and efficient administration of justice. We will continue to upgrade our processes and also our skills. We look forward to corresponding efforts from the entire profession. If we work hard together in the pursuit of these goals, we will enhance the quality of justice for all who may have occasion to seek recourse from the courts, and that would be a most worthwhile objective. I thank you for your presence, and I wish you all a very happy and successful new year.